Thank you, everyone, for being with us this evening on this online training program to promote laws to reduce corporate power and increase democracy. Even though it says it's 90 minutes, it's actually 60. We'll hang around if people want to ask additional questions at the top of the hour. But technically, we have designed this between presentation and questions to be 60 minutes. All right, this program is sponsored by the Law and Research Committee of Move to Amend that has developed this resource page of corporate constitutional rights. And just before going any further, just wanted to share with you and let you know that, again, this program is being recorded and will be sent out to everyone who registered, those of you on the call and everyone else who couldn't make it. So feel free, you don't necessarily have to take notes or try to memorize everything that is being shown. Please put yourself on silent and mute yourself if you haven't done so already. If you have questions, feel free to put them in the chat or comments, and those will be noted. And when we have a break, there's going to be a couple of them. We'll have an opportunity to share those. And at the end of this program, when we go back to showing all of you, then there'll be an opportunity for you to, raise your hand, and if you care to be recognized. Okay, so the presenters this evening of this program are myself, Greg Coleridge, and Jenny Spanos, who are co-directors, as well as John Fioretto, who is a retired prosecutor and member of our Law and Research Committee. The agenda for this evening is, after a brief introduction of Move to Amend, most of info about you're already very familiar with. John is going to describe what we've agreed to be the 4 state-level statutory reforms that we're offering for your consideration to do with as you will in your community. That will be followed by a question-answer period, and then we'll move to sort of a second focus area on how to organize and lobby if you may be interested in your part of the world at trying to choose one of these to work on within your own affiliate or with others in coalition. So Jenny Spanos will talk about that, share some information, and then the program will sort of, at least this part of it, the shared screen will end, and another period of question and answer. And then again, by the top of the hour, we will formally conclude, but again, be willing to stick around for any comments or additional questions. As you may know, Move to Amend is a coalition of hundreds of organizations and hundreds of thousands of individuals committed to social and economic justice and in corporate rule and building a vibrant democracy that is genuinely accountable to the people, not corporate interests. Our principles and values, again, as you may know, 5 of them, they've been these from the get-go, focused on anti-oppression and solidarity organizing, coalition, and movement work, some of which hopefully you may be doing as part of this process and this project. Grassroots organizing, again, where you are. Dedication, we've always been to political education, this being an example of. And finally, the interdependence of being politically and economically independent, which go together. Our goal, so at Move to Amend, is to, as again, pass the We the People Amendment. But secondarily, just as important, to provoke discussion and organizing about how to make real, to go beyond the amendment itself, the promise of democracy, through constitutional renewal that goes wider and deeper than simply the amendments. Our primary goal has always been, again, from 2010 when we began up to the present, to end the influence of money in politics and corporate constitutional rights through the constitutional amendment, which in this session is H.R. 54, based on the conviction that only change achieved through an amendment is lasting. So that's sort of the undergirding of what it is we do. But we have never, again, from the beginning, been opposed to what we're going to be addressing this evening, which is strategic legal stepping stones. These are more immediate, attainable proposed laws that expand democratic possibilities by reining in corporate power especially those that directly reduce the power of corporate entities from, as they have been for over a century, hijacking the political process. Reforms, however, should always be put in context, that they are merely laws that can be, just as they can be created today, they can be uncreated tomorrow, reverse. And they can't, of course, overturn constitutional doctrines that a corporation is a person and political money equals free speech. So what is and why work on statutory reforms? Why be involved in this process, this consideration? Well, we've heard, whether it's from your group or others, that some individuals and some groups are looking for a different project, a different campaign to work on. Working on immediate statutory reforms, laws, again, are immediate and can be applicable to specific issues that you may, as an individual or a group, be interested in, or those organizations you work with may be interested in. So it's just a tremendous opportunity to connect and to outreach with others, individuals and organizations. Laws, quite frankly, are more winnable, are they not, than constitutional amendments. It's an opportunity to educate on corporate power and rights, again, as a stepping stone, and to discuss and to help people understand sort of the distinction between statutory versus constitutional change. It's a good excuse. It's a great way to get media coverage, again, because it's working on more immediate and applicable to specific issues and be more winnable. And again, because of that, who doesn't love a group that's winning? So it gains more new supporters. And finally, because ultimately you're working at the state level, it's an opportunity to develop relationships with state public officials that you well know is important when trying to pass and affirm and validate the We the People Amendment at the state level. So basically, as Victor Hugo says, nothing is as powerful as an idea whose time has come. We believe ending corporate constitutional rights and money is free speech is an idea whose time has come, and that a good stepping stone toward that goal is a statutory reform. So with that, I turn it over to John.
Thanks, Greg. Go ahead and move it on to the next slide, please. Okay, there you go. We have 4 proposed statutory reforms we would like you to consider. I'm just going to go through them briefly, and then we're going to talk about each one of them separately. Charter revocation, corporate 3 strikes, requiring a shareholder vote before political donations can be made with corporate funds, and prohibiting foreign influence corporations from spending money in elections. Next, please. Okay, first, why these 4 reforms? We did look at least the same amount more, and we thought these were conceptually simple and easy to understand. We think they'll be popular. We know that they're fair, and all of them will advance move to amend's efforts towards a constitutional amendment by shining a light on corporate bad actors and bad conduct. Next, please.
Just a real quick note for individuals who may have questions. You may notice in the bottom right-hand corner, very lightly, I could make it darker, unfortunately, is a number of the slides. So you may want to just note, if you have a question, what number slide it's on, so that we can go back. Okay, sorry.
That's okay, Greg. Thank you. And you also reminded me of something. You will have access to these slides afterward, so you don't have to take copious notes and try to jot down the sources that are cited in this part or Jenny's part of the presentation. The next thing you may think is, I don't know anything about these topics. Okay, to hopefully set your mind at ease, you don't need to be an expert. You don't have to draft the legislation yourself. Usually states have special lawyers that do this. You don't even have to have an example of where your idea has already become law, although this helps. And where we do have such examples of such laws, they're in the presentation. Nor do you have to have any specific experience lobbying state government. All your prior move to amend experience lobbying Congress is applicable. What you need is a good idea, and we hope we're giving you several here, and you have to be able to support it, and all of this does take work. Next, please. Okay, now we're going to go through the 4 proposals. All right, charter revocation, and sometimes this is known as quo warranto. I'm just going to mention this at the get-go. Quo warranto is an old Latin legal term for one way to revoke a corporate charter. Because some of the laws, and Greg's state is one example of this, where they still use this terminology, we wanted you to be aware of it, but most, I think, of the states don't refer to it that way, but we wanted you to be aware of it, but we're just going to refer to it as charter revocation. For a company to become a corporation, it must incorporate. This requires filing articles of incorporation, which are also called in some states corporate charters, articles of association, or a certificate of incorporation, depending on the state. To keep it simple, we're going to call them charters. Every state and the District of Columbia, except Alaska, has the power to dissolve or revoke a corporate charter when the corporation violates the terms of its charter. Next, please. Okay, what's the rationale for these laws? States have the power to create corporations, so they need the power to regulate them when corporations violate the law or their charters. This has long been the law in the United States, and we quoted a very old case here, which, using somewhat archaic language, basically says that, hey, if a corporation doesn't do what it's supposed to do under its charter can be revoked. Next, please. Has this been done before? Yes, numerous times by numerous states. The examples on this slide are an extremely incomplete list. You can find more in the source cited there and in other sources. But just to give you some examples to give you a feel for this. In olden times, when private companies built turnpikes, if the corporation that got a charter to build a turnpike didn't keep it in good repair, then that corporation could lose its charter. For any kind of fraud, negligence, or misconduct, a corporation could lose its charter in Rhode Island, although that's more generally applicable with other states as well. A number of states revoke charters for a number of different types of corporations simply for exceeding their powers under the charter. And Virginia, and again, this is just one example, there are other states that have this kind of provision, can repeal a charter by special act of the legislature at any time. Next, please. So what are some of the issues involving charter revocations? They're usually done by the state attorney general, although this varies by state. Attorneys general have gotten out of the habit of bringing these actions. However, can you think of one recent example? And the hints are New York and orange hair. And unless you've been living under a rock, you probably know that Donald Trump, his family members, and a number of his corporations are being sued by the New York Attorney General for business fraud. And one of the things that the New York AG is trying to do is take away their certificate of incorporation. In other words, remove their ability to do business in New York at all. Now, despite that, under each state's law, what is sufficiently bad enough to warrant a revocation is going to vary, and there may not be clear or recent authority on these issues. This is something you're going to have to look at state by state. If the responsible agency doesn't take action, can the public enforce a charter revocation on its own? Depends on your state law. Next, please. Okay, second proposal, corporate 3 strikes. This is another form of charter revocation. I think you all know what 3 strike statutes are. So if a corporation committed 3 or more violations, major violations of law, then it would lose its ability to conduct business by having its charter revoked. Next, please. What's the rationale? Well, first, fairness. about 30 states have 3 strikes laws for individuals convicted of crimes. Should corporations be treated any more leniently? And secondly, effectiveness. Corporations frequently reoffend. 3 strikes would incentivize them to follow the law. Next, please. Has this been done before? 20 years ago, here in California, a state senator introduced a bill that would have introduced corporate 3 strikes. It passed its initial committee, but failed in its second committee hearing, but in 2 very close votes. If you look at the legislative history that is provided in the sources cited on this slide, there were many, many more organizations in support of this bill than were against it. And the ones that are listed on this slide just give you some flavor for how widespread the support for this was. Next, please. So what are some of the issues pertaining to corporate 3 strikes? And I'm going to render a few opinions here. First, should it only apply to large corporations? Yes. Small corporations aren't the problem. Joe the plumber, who incorporates his single person business because he's afraid of getting sued and losing his home, is not what we're after here. Secondly, what types of violations should be deemed strikes? 2 different approaches you can look at. As with the criminal 3 strike statutes, a lot of them will specifically list this crime or that crime and have a whole list of them. But there's a more general way to go about doing this. And another suggestion has been anytime a corporation does something that kills somebody or causes them to be fined or otherwise penalized for $1 million, any situation involving either one of those 2 instances could be considered a strike. Once again, this is something you've got to give some thought to and talk to your legislative sponsor about. And finally, who is going to enforce this law and how is it going to be enforced? Regardless of how those questions get answered, it's always good to have a public enforcement option, because if the public agency doesn't do its job because of politics, then having the ability to enforce it with citizen suits is very helpful. Next, please. Third proposal, to require shareholder vote before corporate funds are used for political donations. Normally, the consent of shareholders in a corporation is not required before a corporation donates money to a political campaign or candidate. Only the board of directors need approve it. Next, please. Why is this necessary? Well, corporations may espouse lofty bipartisan and humanitarian goals. However, often they contribute to politicians, organizations, and measures that contradict these goals. Requiring shareholders to approve corporate spending on politics would provide shareholders with the opportunity to disapprove expenditures that don't align with their values and shine a light on what otherwise would be hidden as dark money. Next, please. Has this been done before? Again, a law was introduced, and in fact, just 2 years ago in the last Congress, but it never got out of committee. The Shareholder Protection Act of 2021 would have required a specific description of any expenditure for political activities for the coming fiscal year to be sent to shareholders. Note, it didn't specifically require a vote, which we think it should happen. Violations would have been discouraged by a civil penalty of up to 3 times the amount of the political expenditure. And again, keep in mind, even though this was a federal law, it could be done at the state level. Next, please. Okay, what are some of the issues? Corporate managers cannot make decisions for diverse shareholders as well as the shareholders can make them themselves. Also, corporate donations have been justified as maximizing shareholder wealth. In other words, corporations wouldn't be donating money to politicians if they didn't get their money's worth, and usually a lot more out of it. that all may be true, but recent scholarship has found that companies that spent heavily on politics perform more poorly than others as corporations. So there's a good argument to be made that there are better ways to spend the corporate money, and it ought to be the shareholders who are deciding this. Next, please. Last proposal, prohibiting foreign influence corporations from spending money in elections. Existing law now prohibits, federal existing law, contributions and expenditures which are made directly or indirectly by or from foreign individuals in connection with any federal, state, or local election. This proposal prohibits foreign influence corporations as defined from making political contributions in state and local elections. Next, please. What's the rationale? Foreigners have allegiances and interests that differ from what's in the national interest of the United States. They are rightly prohibited from spending in US elections. However, not preventing foreign influence corporations from donating to state and local elections is a huge loophole. Next, please. Has this been done before? Yes, and in fact, just earlier this year, for the first time, Minnesota became the first state in the nation to pass such legislation, the Democracy for the People Act. California is considering a similar law, and the California legislature's bill analysis references a similar measure that already passed in Seattle. Next, please. Issues. Okay. On its face, a proposal to prohibit foreign government-controlled corporations from donating to an election in the US seems like a no-brainer. All right. We don't have enough time here, but there are other issues with this proposal. The California legislature's bill analysis, which again has previously been cited in an earlier slide, gives those reasons. And one of them it raised is that the bill might be found unconstitutional under the Citizens United decision. Next, please. This slide and the next one are my attempt to break down the definitions of what a foreign investor and what a foreign influence corporation are. And we're not going to go into them now in the interest of time, but I thought, even though this is a paraphrase and not the actual language of the Minnesota statute that passed, this might be a better big picture for you to get into the topic and understand what these terms mean. And I think you can go ahead too, Greg, please. And one more. Okay, before we get to Jenny's part of the program, in which she's going to tell you how you go about actually trying to get such proposals passed, do you have any questions now about the proposal themselves?
Okay, so this is Margaret. I was monitoring the chat. So there were two items in the chat. One is a suggestion of a further resource, a chapter on charter revocation in the book, Corporations Are Not People by Jeff Clements. And then Mark Harding had a question about transfer, probably either in the 3 strikes or the charter revocation. What would prevent transfer of assets and personnel just to a different corporation if a corporation were dissolved? So they were just playing musical chairs.
Right. One method that I have seen to try and prevent that is there are restrictions on who can be a member of the board or an officer of the corporation. So in other words, you can put language in the bill that says nobody who has previously served on a corporation whose license has been revoked can serve on another, corporate board. So that's one way of doing it. I'm sure there are others.
John, if I might, I think that the question may also have included the sort of that Margaret said, the musical chairs component of if a company thinks, uh-oh, it's going to have its charter revoked, I'm going to, switch the assets to another company. Has it not been done where a court, maybe even under the Trump sightings, where there's been a call to freeze the assets of not being able to transfer?
Yes, that has been done. Well, Trump's case is the example of that. Yes, that has been done there. And if it looks like whatever the legal proceeding is called, and whoever does it, once you end up in court on it, if the judge thinks that this looks like a case where revocation is going to occur, the judge usually, and when I'm put usually in quotes because we haven't looked at the law of all 50 states, but my understanding is usually the judge will appoint a receiver, and that would be some person who holds the existing assets of the corporation to make sure that it can be wound up and the assets appropriately distributed and not just taken and put into another corporation. So I hope that's at least a partial answer for what you raised, Greg.
Or Mark, originally.
Mark, I'm sorry.
Yep.
Yeah. So I'm monitoring the chat because who can't see it?
I can't.
Everybody else can see it, right? But you can't, Greg, or you can't, John?
No, I can see it.
Okay, so can you, so Paul had a comment, which I think everybody can see. And then Pat has a question about what would be an example of exceeding the authority of their charter.
Well, this might not be very helpful for people who aren't from California, but since most of the people from the call are on California, I would argue that Pacific Gas and Electric, which has started fires that killed many people, not done proper maintenance and resulted in several explosions that again killed more people. I think in our state, they're the poster child of a corporation that should have its charter revoked. So I think that would be, or those would be good examples. Now, I haven't looked at the law specifically in California, to see when was the last time a charter was revoked and what was it for. And obviously that would have to be done in each case. Before approaching a legislative sponsor. But at any rate, I think anytime you're not taking care of your business and people are getting killed or harmed, and this is something that's gone way beyond anything that can be handled by, excuse me, a lawsuit or two. There's just continued behavior. And I think the Trump's case is a good example, because what the AG is proving up there is a 10-year pattern of conduct in which Trump and his cronies and their corporations have repeatedly engaged in the exact same kind of behavior to get favorable loan terms. There's this isn't a mistake somebody made. This is a corporate policy, just like you could say PG&E's decision to pay out a lot of dividends to the corporation instead of putting more money into maintenance to prevent fires is another corporate decision that has inured to the detriment of the people of the state.
So that would be 3 strike stuff. Exceeding the charter, there's historical examples, like if your charter is to build a turnpike, but then you also dredge a canal, if your charter doesn't cover dredging a canal, then you're exceeding the authority. You would have to incorporate in order to dredge a canal. But modern charters probably don't include that kind of specificity. So that would be an important
Yeah.
issue to look at.
Yeah. And again, because of in the interest of time, didn't want to get into the history of corporate charters throughout the country. But since the times of a lot of the laws that were cited earlier, corporations now get chartered through what are called general incorporation statutes. And they are much more general. And a lot of them basically, corporation can do anything that's lawful, basically. You can sell shoes, well, if you're Elon Musk, you can, you can have Twitter. I mean, he has all separate corporations, but theoretically a corporation could do all the different things he's doing in one corporation. But once again, if you repeatedly, chronically, and as a matter of policy, violate the law, I think that makes you a candidate for revocation.
Right.
One other example, though, of not breaking the law is in my state of Ohio a number of years ago, maybe about 20. The Cleveland Clinic, one of the more well-known medical facilities in the country, they made the mistake actually in their original charter, somewhat up to date, of actually being somewhat specific, saying that, our purpose of business is to expand medical services. Okay, well, they were in the business 20 years ago of taking over a number of other hospitals that were in lower income communities. So I worked with Dennis Kucinich at the time, who was a congressperson, who contacted a state representative to call for the revocation of the charter of Cleveland Clinic Corporation, because by closing down a hospital, they were by definition limiting and reducing the potential medical care. So they weren't breaking any law, but they were breaking their charter. And they backed off.
If it's okay.
We'll need to move on because of time, but Bob has a question about, can we get a quick review of charter in each state? No, you have to look it up for your state. Does one charter cover all states? No, each state has its own. And does one state law affect other states? Not legally, it might influence people's thinking, but the law in the state applies only to the state.
Yeah, let me real quickly respond to Paul's question. Delaware is in the business of issuing corporate charters. They might not want to bite the hands that feed them. This is true, Paul. However, even if a corporation, and most of them are registered as corporations in Delaware, when they want to do business in another state, they still have to go through some kind of process in that state. And that's where you might be able to get them when they go through that process. And just one final comment before we turn this over to Jenny. I strongly suggest if your group meets and decides to pursue this, then you think about who in your area who is an attorney who, even if they don't practice corporate related law, can do a little research for you in the area, because that will hopefully get you going in the right direction and not off to a wrong start. Any rate, enough said. We're going to stay later to answer more questions if you would like, but take it away, Jenny.
Thank you so much for that, John. Good stuff. Hi, everyone. Great to see you all. For those of you who do not know me, my name is Jenny Spanos. I'm one of the national co-directors for Move to Amend Coalition. And thank you all for taking time to learn ways to blunt corporate rule and increase our democratic power. The key is to know and exercise your power and to not give up, being persistent. We're going to explore some effective state advocacy strategies, go over the importance of relationship building, and strategies for ultimately achieving our legislative goals. Every state has its own set of rules considering and enacting bills. So it's really important to understand your state's legislative practice and processes. So you can reference the basic rules and guide the movement of the bills through your state legislative process. And that'll help you understand why the bill has reached its current progress and, of course, likelihood of future success. We have linked here a great resource for the explanation of your processes for each state, statescape. And this is also going to be on the statutory reform page, all of which will be sent to you in the follow-up from this program. So as you know, the We the People Amendment is a marathon, and these statutory reforms are strategic tools to ultimately end corporate rule in creating genuine democracy. First, you want to sign up to organize or participate in a campaign and to promote the pro-democratic, anti-corporate statutory reforms. Second step is determine what reforms to pursue. So you're going to ask your groups that you're currently working with or wish to work with that believe, what they believe would be the best in furthering the issues that they're working on. Potential groups to approach include MTA endorsing orgs located in your state. Once a reform is collectively identified, you and your affiliate and allied groups and organizations will recruit friends, neighbors, contacts through social media. Remember, these are state statutes, so anyone in your state is a potential ally. So you can also use our database and send emails to blast or blasts, as we call them, to the MTA list, asking people to sign up for the campaign. Third step is to identify potential state legislators to sponsor or co-sponsor. Find out what the legislation that they've already introduced or support, what state representatives sit on key committees. There's a template that's going to be linked in the webpage that can help you in creating bios on prospective sponsors and co-sponsors. Remember, it's also about relationship building, because these folks may be in the federal office, come next election or the next one. Schedule your meeting. Contact your legislator's office and ask for a meeting on Zoom or in the office if it's practical. Step 5 is to prepare for the meeting. A good way is to have your group watch the promotion of the pro-democratic, anti-corporate power statutory reforms, and review the background information that you have gathered once you've decided which reform you're going to use. And we'll just call it 3 strikes from here on out, but you may choose one of the other 4 reforms. You want to hold a prep call, and a lot of you have already done this, so you're what I consider experienced lobbyist, right? But you want to hold your prep call, review the meeting roles, and make sure that each of you are clear on what to say and how to make sure to get to the ask. Once you have done this, you want to send a blast to constituents through your whole state to advance and ensure that the office gets calls to put this on their radar before your meeting. And if you would like and move to amend national organizer to join your meeting, just give us an email. Send us an email and let us know at affiliate.support@movetoamend.org. Step 6 would be to hold a meeting. Follow an agenda, because you'll only get, as you know, 20 to 30 minutes. Take really good notes and keep track of any questions that you get that you can't answer on the spot, and commit to following up with your answers. And don't forget to make your clear ask. Will you co-sponsor 3 strikes reform statute? Number 7 is really important, your follow-up. Send a thank you note, email with any requests to the staffer, and then mail a thank you note to your legislator. Then you want to send email blasts to the constituents in your area, asking them to call each week to keep the pressure up. In 2 weeks, send another email and call the office and ask for a response. Be very persistent. Keep trying every 2 to 3 days until you get a response. Step 8 is to celebrate or escalate. As y'all know, sometimes it takes a while, and often This is all it takes, especially for state legislators who agree with your goals. But if you don't have a commitment yet, it's time to escalate your tactics. And we can work with you to determine how to escalate appropriately, from stepping up phone calls to organizing letter writing campaigns, car parade around the office, delivering petitions to their home, that type of thing. Remember that there's power in numbers. So, you know, things to consider for potential allies. Next slide. Some potential allies to consider for your outreach are interest groups that share our values, right? Good government groups like League of Women Voters, Common Cause, Public Citizen, environmental groups and climate change organizations, 350.org, Sierra Club, the CCL, these type of groups that you're already involved in, right? Or other members of your affiliate groups are. And groups like Indivisible. Of course, it's really important to reach out to historically marginalized communities that are already on the front lines of the struggle against the impacts of corporate rule. You know, Black Votes Matters, Indigenous organizations. Reach out to the media, newspapers, independent newspapers, traditional and online, local TV and radio, social media, political parties. Some organizations, you know, Green parties, progressive groups, labor organizations are always a key power source to go to. Seniors, consumers, small business, academia, you know, student organizations can be really powerful and give a lot of energy to the work you're doing. Include the faculty. You know, who do you know? Who do they know? And who can lend credibility to your effort? What other groups are your affiliate members associated with? Research business owners and community leaders. Do any of them have aligned views? Some important things to keep in mind when you're meeting with your lawmakers or someone in their office is to assign a clock watcher. Don't waste anyone's time. Get to the point fast and focus on your issue. Keep your visit to no longer, you know, than 20 to 30 minutes. Lawmakers will appreciate your consideration of their busy schedules. Use examples to communicate your position. Explain the logic of your position in straightforward terms. How many people will be affected? Always detail information you can give with it when you're explaining your logic, like, and these are must leave behinds for office visits, information like this in your packets. In all communications, be sure to include the bill number or name of the legislation or the regulation, as well as your name, you know, your postal and email addresses and home and office numbers. Be nosy. Ask your lawmaker to state their position. If their position agrees with yours, ask what you can do to strengthen that support and how you can get others to help support them. If their position is different from yours, ask what information or show of public support is necessary to change that position. Do the reach out. Include lawmakers in your mailing lists. Make sure you're on their list as well so you can see what they're working on and how that relates. Remember, there's power in numbers. There's strength in numbers. This is true in financial support as well as all forms of communication. Remind your lawmaker how many people in your organization share your position. And again, just think in volume, in terms of volume. Be prepared to put in the work. The more responsibility and involvement you assume, the more vigorous and committed and supportive you can expect from your lawmaker. Be flexible. Sometimes you and your lawmaker are not going to, well, you're going to have to compromise sometimes. Assess what you can realistically achieve and work on the rest later, and be patient. Sometimes decisions can take months. Educate. What better way to describe the importance of an issue to a lawmaker than to show him and her up close and personal? Invite lawmakers to your office or other appropriate locations to put a face on the issue. Most state lawmakers are not full-time and they value the opportunity to learn about an issue from adept resources in the field. Be a good winner and a good loser. Don't burn your bridges. Your adversaries on one issue may be your ally in the next. You don't know, you don't have to agree with everything. Write thank you notes to the lawmaker, no matter what the outcome is. Invest in the future. At least 6 times a year, take 30 minutes of your time to contact your lawmakers by letter, phone, email, or office visit. This will make you about 99% more active than all citizens, and therefore about 99% more legislatively successful. Remember, lobby your state legislator is a year-round effort. Just another tidbit, it's okay to say, I'm not sure, and I'll get back to you on this or that, whatever it is, ASAP. And be yourself. Your representative works for you, and it's also the staffer's job to listen to their constituents. Again, don't forget to sign up. Check out our in-depth resources on the webpage. And also, we're always available to assist if you have any questions or follow-up meeting as necessary. I want to thank you all, game changers. Just to reiterate that we the people can no longer wait to make real the promise of democracy in the US. It is still time to push for systemic constitutional change, but use these statutory reforms as the strategic, educational, and outreach tools that they are. While we continue to move to amend the Constitution by passing the We the People Amendment and creating the world that we all deserve and frankly require. I want to open it up for any questions that anyone has now. Does anyone have any questions on this or any follow-up questions for John? Well, maybe first I can share my screen and just kind of show you the resources that we have available so that you know where to find it. And
There's one hand up by Michael.
okay, Michael, go ahead.
Yeah, when you talk about banning, requiring shareholder approval for campaign contributions and expenditures, should you also require consumer or customer or employee approval as well?
Michael, you raise an excellent issue, and there have been a variety of law review articles that have made that exact suggestion. And they've said, the people involved here are not just the stockholders. They're, the employees should have a voice, consumers should have a voice, et cetera, et cetera. So, you can make that ask. I think if we were to get even just a bill that says shareholders have to take a vote, that in it of itself would be a huge victory. And the way legislation usually works is it's kind of like negotiation. You ask for A, B, and C. You wind up compromising and getting C, and then you go back and ask for A and B later. And so it's a process. But thank you for bringing that up, because, some people think that all the constituencies of a corporation should be involved in all of its functions, but that's not the state of the law now.
What's oftentimes called stakeholders. Paul.
Just to raise up, Mark asked in the chat, does the revocation of a corporation too big to fail result in the state temporarily assuming control until new management can be assigned to protect the customers and other stakeholders? And John responded that that's what a receiver does in a case.
Mm-hmm.
Yes.
Steve.
Paul.
Yeah, I'd just like to comment that with respect to stockholders having a vote, on corporate expenditures for political contributions, the polls show that heavy majorities of Americans don't like money in politics. So if a law like that were passed, I expect that, initiatives to donate to political action committees or politicians would often be struck down would lose the vote because of people's antagonism towards money in politics in general. But I just thought I'd throw that out there. That when we're talking about, do you just go for the shareholders or should you go for the whole community? I still think just getting the shareholders would be an easier law to pass, and it might be effective.
I'm not sure this is going to be exactly responsive, Lawrence, but some of the law review articles and other articles I read in putting this presentation together said that when you look at who the shareholders are, and when you look at who the board of directors are, and when you look at who the corporate officers are, you're not talking about a group that looks anything like the American public. Now, over the past, few decades, a lot more people are invested in the stock market and corporations than used to be. Okay. So it's changing. And also there's been a huge emphasis on environment, social and governance issues, social, also known as socially responsible investing. Yeah. So all of that, and for many years, there have been stockholder activists who have tried to bring up various pro-consumer and more progressive issues to the fore in corporate votes. So all that said, we're in a system in which you don't get a vote by person, you get a vote by share of stock. So there may be a huge number of people who would support this, but they're probably the people who own a lot less stock than the people who would oppose it. So just getting a basic proposal to require a vote would be a huge victory. At any rate, enough said.
See,
All right,
Laura,
Lauren, I see your hand.
Thank you. Yeah, I had to be here over here at the UC Berkeley Labor Center and just got out of the meeting. Will this be? I kept up with part of it, but will this be recorded and broadcast later?
yes.
Yeah.
Will be
Excellent. Thank you so
recorded and shared with everybody at this meeting. And this might be a good time for me to just show real quick before Deb or anybody else has to get off, where you can find this on the website.
Excellent. Thank you.
And we'll go back to questions if that works for you. So you just go to movetoamend.org and go, let me see. Move this thing out of my way. Go to Get Involved under Action Campaigns, where you can find the We the People Amendment, the petition, and promoting laws and increase democracy and reduce corporate power. So here's the page. And if you scroll down, it has the explainer there. If you scroll down, underneath each one of these tabs are all of the documentation, the cited sources and information that John shared with us. And then as you go down, you find the statescape, which gives you, like I said, this is a wonderful, wonderful resource to find your legislative process. Every state is listed under here, step by step, and links to the different states. So that's a great resource to find out how to operate within your state to pass the law or statute. And then under each one of the steps are the explainers and more resources, whether it's the templates for creating bios on your co-sponsors, how to set up a meeting, background information. And then at the bottom is where you would sign up to let us know that you're working on this campaign so that we can not only keep track, but also provide assistance.
Great.
Margaret, you had your hand up?
Yes, so on the topic of shareholder voting or other stakeholder voting, there are also a lot of large institutional stockholders. And I know here in California, people have been pressuring the state employees retirement system to divest from certain stocks. So that's another way to bring pressure. You know, in the case of getting a law passed, if you could get large institutional shareholder groups or institutions to pressure the lawmaker about passing the law, that would be sort of a variation on the same strategy.
That's good.
Indeed.
I received a direct message. Is Citizens United no longer one of your issues? So Citizens United, of course, is one case that was decided, and move to amend is still 100% working towards moving to amend the Constitution and passing the We the People Amendment. This is designed for folks who have already got it passed, resolutions throughout their states and at the state level, who are looking for other ways to blunt corporate rule. So we are still definitely working to overturn not just Citizens United, but every insane adjudicated corporate constitutional right. Because of course, corporations are not people and money is not free speech, and it should be regulated.
Other questions, comments? We promised this would go an hour. But if people wanted to stick around, welcome to do so. We certainly shall. If you feel like you need to leave, we won't be too personally offended. Maybe somewhat, but not a whole lot. So, but anyway, this will go out within the next day or two. The recording as well as the link that Jenny mentioned. Other questions or comments?
I would just like to comment. I would just like to expand a little bit on what Jenny was saying. We're in no way abandoning the effort to amend the Constitution, but in order to further that effort, we need to constantly educate people. And a campaign like this serves a number of purposes. One, it increases our educational outreach. It's a way to talk about corporations, corporate rights, what's the problem, so on and so forth. And also it's a way of energizing people. And people will, who are not used to lobbying, will discover that actually it works. And then they might feel more motivated about amending the Constitution. So it's just part of the same effort. And it's a way to keep going for people that have already gone pretty far and are kind of looking for what would be the next step to keep up their momentum. Pass.
Yeah. And it ties into some existing issues that maybe groups are really focused on that are here. You know, one thing that has come up, you know, and I'm sure maybe your parts of the world, certainly in ours, is the whole issue of landlords. You know, landlords are not necessarily, they can be part of a company, not a big company necessarily. So, you know, John mentioned maybe focusing on big companies, not small, but there are some, you know, decently sized landlords that aren't necessarily breaking the law, but are doing harm to their tenants. This could be a tool in terms of trying to revoke the charter of that, you know, in a community. It's a big landlord, but they're still chartered at the state level.
Just two other comments, if I might. If a number of different states started having activity on a number of these fronts, that is going to communicate a message that these issues are important. And also, if you're a business, especially a big one that does business throughout the country, you don't want to have to deal with different law in each state. Now, this can cut both ways. That means they can go to Congress and try to get a federal law that preempts all the other state laws. But it can also mean that, you know, somebody might say, hey, I would rather just get my company completely out of the political game and just focus on business. And there are some corporations that are already saying this. Also, the people that we are going to deal with at the state level, some of them are going to wind up in Congress. And so, you know, basically that's how politics works. You work a lot of times you work your way up. So whatever connections, networks, and alliances you form in engaging with state legislators, sooner or later is probably going to be helpful for the national effort to pass the amendment.
Great. Before other people need to go, just kind of doing, you know, just taking the temperature, if you will. Having heard what you've heard and seen what you've seen, though you've not gone to the page that Jenny went to examine the links thoroughly, but just based on what you know, are any of you interested to explore this further where you are? And if so, would you mind putting your name in the chat? Just kind of curious. Or say you're interested in the chat. You can either read your name. Great. Feel free to continue to do that. Any other questions or comments? Well, if not, maybe we can call it an evening. Just want to thank you all for being here this evening, taking part in this. John, Jenny, any other closing thoughts you would like to make?
No, just I was going to ask the people from the Law and Research Committee that are on the call to stick around after everybody else gets off for a quick debrief.
Good enough. Yes, Paul.
Just one last comment or idea, thought, contribution, whatever. There's a documentary called There Ought to Be a Law. If you have never seen it, I highly recommend it. It was done by Shoshana Hoos, a woman in Maine, made the documentary about a woman whose son committed suicide. He went out and bought a gun and killed himself. And she went to her state legislator. She didn't want any other mothers to suffer the way she did. And she tried to pass a law that required a 10-day waiting period before, you know, for anyone under the age of 21, they had to wait 10 days before they took the delivery of the gun. They could pay for it, pick it up 10 days later. She was convinced if that law had been in place, her son would be alive. And she went through this legislative process, much like the one that was described tonight. And at the 11th hour, of course, the NRA jumped in and killed it. But it's a heartbreaking movie, but it shows a couple things. It shows it sort of gives you a feel for the process and what you go through. She got with her state legislator, they crafted the bill and got co-sponsors and did all these things. But it also illustrates the influence of money in politics in a very dramatic and graphic. I mean, it's a true story. So it's well worth watching. It's about an hour long. And
Title
I've seen
again?
a couple. It's called There Ought to Be a Law.
Great. Thank you for that.
It's a state thing in the state of Maine. It took place. Yeah.
Great.
Thank you, Paul, because Patrick McKercher, who's still on the call, he's our education lead for our affiliate. And Patrick puts together a movie night every 1 to 2 months. And it's usually a documentary that it has to do with some topic that is affected by money in politics or corporate power. So we're always looking for new documentaries, and Patrick always leads a discussion afterward, and I always find them very worthwhile. So thanks for the letting us know about it.
Happy to do it.
Yeah, thank you. And thanks to everyone else for being on this program this evening. Appreciate it. And for those who did put their comments in the chat, thanks for those. And those who expressed an interest in at least exploring this more, will follow up. Thank you very much.
Okay.
Thank you all. Great seeing you.
Corporations are not people too. Money is not speech. Man, in fact, it's the root of all right now. We have the right to be free. Corporations are not people too. Money is not speech. Man, in fact, it's the root of all right now. Stand up and defend your democracy.
Have you recently read the Constitution? There seems to be some type of confusion. I thought it said the people were the institution and not the corporations that simply want to use them. The truth is currently a fusion of corporate loot and our government that is outright abusive. People need change. The state, it refuses. They're saying we're mistaken. Well, show us where the proof